Nathan Sales is a former Justice Department official and now a professor at George Mason University in Fairfax, Virginia. Good morning. Thanks very much for being with us.
Morning, Steve. Thanks for having me.
Let's continue, and then I want to talk about how the Patriot Act has been implemented. But take us back to 2001, 2002. You were inside the Justice Department. We talked with Paul Singer on just how quickly this bill became a law just 6 weeks after the events of September 11th in New York, in Shanksville, Pennsylvania, and here at the Pentagon. But from your standpoint, what was happening inside the Justice Department?
What was happening inside the Justice Department was a massive effort to keep this from ever happening again. And so there was a sense very early on after 9/11 that we needed to equip intelligence officials and law enforcement officials with new tools that they could use to detect terrorist plots before they happen and interdict them before they can materialize into the types of attacks that we saw on 9/11. And the Patriot Act tries to do that in a number of different ways. It has a couple of key goals, one of which is updating the law to the technology. Laws that had been written in the 1960s and 1970s to govern analog communications suddenly looked terribly out of date in an era of emails and digital communications. Another thing Patriot tried to do was level the playing field. There were a number of tools that ordinary cops could use to investigate drug dealers, mob bosses, and so on that weren't yet available for intelligence officials who were trying to investigate potential terrorist threats. So another thing that Patriot did was equip our intelligence officials with the same sorts of tools that law enforcement had been using for decades. And a third thing that Patriot tried to do was improve coordination and information sharing, make sure that the right hand knows what the left hand is doing so that intelligence officials and law enforcement officials can mount a concerted effort against terrorism.
Let me go back to the debate that we had following the bombings in Boston, where the administration was criticized for not trying to connect the dots or keep track of what the Tsarnaev brothers were doing. And then, of course, we have the debate over the eavesdropping by NSA. And the question is, how can the government be tracking phone calls?
Right. Well, how can the government be tracking phone calls? The answer to that question has a lot to do with the oversight mechanisms that have been put in place to prevent the kinds of abuses that we all worry about, privacy abuses and civil liberties abuses. Under the programs that have been disclosed in recent days, first of all, there's an awful lot that we don't know. Your previous guest talked about overclassification and declassification of some of the information. We're still waiting to find out the exact contours and exact details of these programs. But sort of reading between the lines, it looks like what's happening is the government is asking the special FISA court for permission to collect large amounts of data about phone communications. Now, it doesn't look like they're vacuuming up the content of the call. What they're getting, it appears to be, is just the phone number that has been dialed, the length of the call, other types of transactional information. Think of it as the distinction between the letter that's inside the envelope and the return address that's on the outside. They're getting the envelope information.
So did this story surprise you, or did you know when you were at the Justice Department that this was taking place?
It surprised me. I haven't been at the Justice Department for about a decade now, so I'm very much out of the loop on current counterintelligence and counterterrorism surveillance programs.
So when the story came out, you were surprised. Why?
I was surprised to learn the details, but I wasn't surprised that the government would be collecting information and using it to try and prevent future terrorist attacks. I mean, in the post-9/11 era, I think we all have a sense that the government would be derelict in its duty if it wasn't doing its utmost to protect us against terrorism. And doing so, moreover, and this is important, in a way that protects important privacy and civil liberties values at the same time.
Let me go through some of the details of the Patriot Act in this courtesy of govtrack.us and some of the provisions, and we're going to hear from Senator Feinstein in just a moment, but Section 215 basically gives easier access to business records. Section 203 allows information to be shared with intelligence agencies. Section 206 is the FISA so-called roving wiretaps that are permitted under the Patriot Act. And also under Section 213, it allows for the so-called sneak and peek search warrants. Here's more with California Democrat, Chair of the Senate Intelligence Committee, Dianne Feinstein.
Section 215, business records provision, was created in 2001 in the Patriot Act for tangible things: hotel records, credit card statements, etc. Things that are not phone or email communications. The FBI uses that authority as part of its terrorism investigations. The NSA only uses Section 215 for phone call records, not for Google searches or other things. Under Section 215, NSA collects phone records pursuant to a court record. It can only look at that data after a showing that there is a reasonable, articulable suspicion that a specific individual is involved in terrorism, actually related to al-Qaeda or to Iran. At that point, the database can be searched, but that search only provides metadata of those phone numbers, of things that are in the phone bill. That person, so the vast majority of records in the database are never accessed and are deleted after a period of 5 years. To look at or use content of a call, a court warrant must be obtained. Is that a fair description, or can you correct it in any way?
That is accurate, Senator.
So, Nathan Sells, we should point out that was General Keith Alexander, who oversees the NSA operation, but the chair of the Senate Intelligence Committee, who's been a strong supporter of the Patriot Act. And I want to follow up on what she said this morning from the Washington Post, talking about the so-called metadata, pointing out that metadata is so rich with clues that entities from Google and eBay to the world's largest spy agency, the National Security Agency, are collecting and mining this deceptively innocent information, email addresses, phone records, as we heard just a moment ago, length of calls, as you just indicated, and unique device serial numbers.
Right. There's no question that the metadata that the NSA appears to be collecting under this program can be incredibly revealing when you look at it. Right. So the question to me is, who's looking at it and under what circumstances? And as Senator Feinstein indicated in that clip that was just played, there appears to be something like a two-step process. The first step is the NSA acquires the information by using an order under Section 215 of the Patriot Act. As far as we can tell, that data then goes into some vast government warehouse, sort of a digital equivalent of the warehouse in Indiana Jones, right? The second step of the process then becomes, under what circumstances can the government look at the data that's been collected? I think the answer to that is upon a showing of reasonable suspicion to believe that the data in the warehouse might be relevant to an ongoing investigation to protect against terrorism. So I think you're quite right that metadata has the potential to reveal very intimate information about our lives and our relationships and our daily business. So I think it's important to understand the circumstances in which the government's looking at that data. And it appears to be only in situations where there is a demonstrated link to a terrorism investigation.
Our guest is Nathan Sales, who served in the first 2 years of the Bush administration as a senior counsel at the Justice Department. He is now a professor of law at George Mason University in Fairfax, Virginia. Our phone lines are open. You can also join the conversation on our Twitter page or Facebook. Let's hear from David, who's joining us from Plymouth, North Carolina. Republican line, good morning.
Yes, good morning. It always puzzles me how people think that we live in a free society and we are governed. Government means there are controls that's going to be put in place. I've worked inside government, I worked in the civilian world, I worked in churches, and we all have governance that we live under. And it surprises me that people think that back in the day when I got my first phone, it was on party line. It wasn't just one person listening, but there were a multitude of people listening on your conversation. It was switchboard. And so things have never changed. We've always been governed. And under being governed, that means there has to be some controls set in place. So whether it be in church, we accept that there are limits imposed upon us in church. There are limits set upon us in government. But the same people that come out of the world, we live in gray, but we try to rule in black and white.
Thank you, David. We'll get a response.
Yeah, it's an excellent point. And I think it's important to keep in mind the distinction between information about the transactional information, the envelope information, the metadata on the one hand, and the content of the call on the other. I think the party line example is a very good one because it shows how your expectations of privacy in the actual conversation you're having are pretty intense. What you say to your wife, what you say to your husband in the privacy of a telephone call or an email is sacred. And we want very strict strict controls on the circumstances in which the government can access that information. Legally speaking, the amount of privacy that we enjoy in the other kind of data, metadata, what phone number did I call, historically that sort of information has received much weaker protections under statutes and under the Constitution. And the rationale for that is basically when you dial a phone number, you are voluntarily conveying that information to a third party, namely Verizon or AT&T. In the olden days, you did it directly. You picked up the phone and told the operator, I would like to call this number. Now there are computers that serve as intermediaries between the one end of the conversation and the other, but the basic principle is the same. When you voluntarily disclose information to Verizon about the number you want to dial, you sort of surrender a measure of your expectation of privacy in that data, or so the courts have held.
This is from Michael Pollan Sr. from our Facebook page. He says the Patriot Act is a good idea that is too dangerous. A citizen's only defense is to remain irrelevant.
Yeah, so it's a good idea. I'd actually stop the sentence there. It's a good idea.
Well, because he goes on to say that once the person becomes relevant, the incumbent powers can search the database and find ways to quietly take down anyone they want to prevent from becoming relevant. The IRS proves that it can and will happen.
Well, and that's why it's important to have strict oversight mechanisms. And I think the most important oversight mechanism that we have under the Patriot Act and under FISA, the Foreign Intelligence Surveillance Act, which is the underlying statute here, is the requirement of judicial review. The government can't snoop around in your phone records unless a court says so. The government can't listen to your phone conversations or read your emails unless the FISA court says so. So it's not so much trust the government to do the right thing. I think it's trust the court to serve as a check on the government, in the same way that the court serves as a check on the government in a variety of other contexts.
So based on that, this is from Jack, who says, what are the penalties for the illegal use of data or metadata that's collected under this program?
That's one of the things that we don't really know yet. And I, for one, would like to know an awful lot more about what sorts of internal controls the government has on using this sort of information. We sort of have to infer what the penalties are from other contexts. And a good example of what can befall somebody who misuses data comes to us from fairly recent history, 2008. You might recall there was a scandal in 2008 about State Department contractors who'd accessed the passport files of the three major presidential candidates. Now President Obama, Senator Hillary Clinton, and Senator John McCain. They were snooping around in the records improperly. It was discovered fairly quickly, actually. And the reason it was discovered fairly quickly is because it's possible to put audit controls on databases, find out who is accessing the database at what time and for what reason. Those audit controls flagged a couple of State Department contractors who were then disciplined. I think they were fired. So that gives some hope that there are mechanisms in place to detect unauthorized uses of information and to hold those who do so accountable.
This morning, the New York Times has an extensive story on Edward Snowden. It's in the A section. It's also available online at nytimes.com. The leaker who was shaped by rebellious culture. And one of the questions is whether or not he will be prosecuted, and if so, under what provision?
So there's a couple of different statutes that Mr. Snowden could be charged under. There's an act called the Espionage Act, which dates from World War I. We talked about the Patriot Act updating the law to account for changed social circumstances. The Espionage Act also is in bad need of being updated. A 100-year-old law that was written in an era of telegraphs. I mean, forget rotary telephones. We're talking about going to Western Union and tapping out your message on a telegraph. So that's one possible set of laws that Mr. Snowden has potentially broken. Laws making it unlawful for government employees to reveal classified information to people who are not authorized to receive it, such as members of the press. Another specific law that he might have broken concerns communications intelligence or signals intelligence. Shortly after World War II, Congress enacted legislation that was specifically directed to the problem of leaks of communications information. And it's possible that Mr. Snowden violated that law as well.
I'm intrigued by this company that we're hearing a lot more about. Its signs are available or seen around Washington, D.C., including across from Nationals Park, Booz Allen Hamilton. What do you know about this firm?
It's a very well-respected firm that does government consulting across a wide variety of disciplines. They have a division that deals with national security matters and counterintelligence matters, and it appears that Mr. Snowden was affiliated with that branch of the consulting firm.
Frank is joining us, Orlando, Florida, Democrats line with Nathan Sales of George Mason University, formerly at the Justice Department. Go ahead, Frank.
Good morning, and thank you for taking my call. And thank you for both being there discussing this. My concern first started with the Patriot Act, and ever since then, there's more and more laws just chipping away at our liberties. We're told that the terrorists, what they don't like about us is our liberties and our freedoms and our way of life. And it seems like the government's only way of combating that is to take away our liberties and our freedoms and our way of life. And it just gets a little confusing when you think of it that way. And, I mean, they can't even come up with agreement on how to defend our own southern border, and where people are coming in illegally, and yet they're taking all our information and looking at it. I just have a hard time understanding that. Thank you for letting me talk.
Frank, thanks for the comment, and that's a segue into this editorial from the Baltimore Sun that is focusing on the ACLU, to get to Frank's point about challenging the Patriot Act. And the Baltimore Sun editorial points out that the ACLU lawsuit makes a compelling case for why, at least, we should be worried.
Well, I think the most valuable aspect of the ACLU lawsuit is it emphasizes the need for more information. There are good reasons to classify intelligence operations, but there is also an important need for the public to be well informed about the national security activities that are being done in our name, after all. This is a democracy. Policy is set by the people's elected representatives with input from the people. So I think it's very important for the government to declassify as much information as possible. I'd like to know more about exactly how the government is using the information that it acquires under the 215 provisions. What kinds of plots, if any, have been disrupted as a result. These are the sorts of things that we need to know in order to make an informed judgment as to whether these surveillance authorities should remain in place, or whether they should sunset, or maybe whether they should even be strengthened. But we can't really have that conversation unless we are given the information we need to form our opinions.
Next is Ed joining us from Albany, New York, Independent Line. Good morning.
Good morning. I just think the Patriot Act, the whole thing is unconstitutional. It was set up right after 9/11, and you ask for proof. Proof is where the black box is. There's never been in history a plane that went down and they didn't find the black boxes. So that's my comment.
Okay, that goes back to an earlier point, which we'll just let the comment stand. We'll go to Chuck joining us from Smith Station, Alabama. Good morning, Chuck. Go ahead, please.
Morning. I have followed this Patriot Act quite a bit, and I think at the time it was put in after 9/11. It was basically put in to deal with terrorists and everything, and I don't really see a lot of wrong with the act as it was written. Unfortunately, the problem is we have a Justice Department going back to Clinton's and everything else. When they went to Waco, killed people, the government did it. Ruby Ridge, the government got involved in that. Oklahoma City bombing, we got Fast and Furious and all these things. The corruption, I think, is in our Justice Department because, number one, this man we call Eric Holder was involved in all of these things, and yet he's the same man who wrote the pardon for Mark Rich for Clinton.
Okay, we'll get a response.
Yeah, well, I think this illustrates the need for judicial review of the government surveillance activities. Any executive branch agency, not just the Justice Department, but across the board, has the potential to break the law. Any human being is flawed and has the potential to do something he or she shouldn't do. That's why it's critically important to have judicial oversight and congressional oversight, making sure that the laws in place are being enforced effectively. And I think we can take some comfort from the fact that in the specific context of the Patriot Act and the Foreign Intelligence Surveillance Act, that's exactly the system we have. In 1978, Congress made a deliberate policy choice to subject the government surveillance activities to judicial review. You can't snoop around in emails today or letters back then unilaterally. You have to go to the FISA court and say, "Mother, may I?" before you're allowed to do that. And I think that helps set aside or quell some of our concerns. Maybe not all of them, but some of our concerns about executive branch overreach.
Again, one of the moments with your former boss, President Bush, back in 2001 with Vice President Cheney at the National Security Agency offices. And there's this comment from one of our viewers, Ron Gums, who says, has the Supreme Court ruled on the constitutionality of the Patriot Act?
Not directly, but the Supreme Court has ruled in previous cases that form the foundation for some of the provisions in the Patriot Act. So, Steve, earlier you mentioned sneak and peek search warrants. In the trade, they're called sneak and peek or delayed notice search warrants. I think a 1979 case called Dahlia versus United States, the Supreme Court expressly held that when you're executing a search warrant, you don't always have to provide immediate notification to the target of the search. And the reason for that is obvious. If you're searching Tony Soprano's house, you don't want him to know that you're searching his house immediately. So you can delay provision of notice that the search warrant has been executed. And in this 1979 case, the Supreme Court said the notion that immediate notice is always required is not just wrong, it's frivolous. That's one of the examples of how the Patriot Act is informed by and rests upon underlying Supreme Court precedents. The Supreme Court hasn't tested that many provisions since, but the Supreme Court's prior case law does form a jurisprudential foundation for what's done in the statute.
And another point on Edward Snowden, again, his whereabouts remain in question, whether or not he is still in Hong Kong or somewhere else. But the Democratic leader in the House, Nancy Pelosi, had this to say this past week.
Well, first of all, I do think that on 3 scores, that is, leaking the Patriot Act, Section 215, FISA 702, and the President's classified cyber operations directive on the strength of leaking that, yes, that would be a prosecutable offense. And I think that he should be prosecuted.
Nathan Sales, based on that, as a lawyer and former Justice Department employee, what's the process involved?
Yeah, so the first part is collecting evidence. It's important for prosecutors to know exactly what Mr. Snowden allegedly did, what data did he have access to, how did he exfiltrate it, that's a fancy word for stealing, to whom did he give it, under what circumstances. All of these highly intensively specific factual questions need to be resolved before you can think about a prosecution. And then once you have a clearer sense of the underlying facts, you begin to think about how those facts map onto the governing statutes, the Espionage Act, the Communications Intelligence Act, and so on.
And we heard from Mike Rogers, the chair of the House Intelligence Committee, who, and I'm paraphrasing, but referred to Edward Snowden as a high school dropout and may have embellished or exaggerated what he knew about the program.
Yeah, so some of the initial reporting on the programs, it's actually 2 separate programs, or maybe even more, some of the initial reporting turns out to have been not entirely accurate. So, for instance, the initial report was that under the PRISM program, the NSA was able to tap directly, and that's a key important word, directly into the servers of ISPs and telecommunications carriers, Google, Apple, and so on. The press has begun to walk that back. It turns out that that may not have been entirely accurate. And the companies that are alleged to have participated in this program push back fairly vigorously on the notion that they'd given the government access to the crown jewels, as it were. So it's quite possible that some of the initial reporting that we've seen isn't going to hold up.
Our next caller is Alistair, joining us from the United Kingdom. This program is carried live on the BBC Parliament channel, so we say good afternoon to you. Thanks for phoning in. Alistair, you with us? We'll try one more time. Go ahead, please. We can hear you.
I have a question. Currently, the European data will be changed so that rather than when a Briton logs on to some of the American servers, data won't automatically go to America but may live here in Europe. And if it's living here in Europe, how does that affect the Act? Are we going to see a division in the data? Is it going to be able to log on to American servers, or what differences might be to that?
A little bit of breakup, but I think we have the essence of the conversation and the question, so we'll get a response.
Sure. So what we're talking about here is the surveillance of foreign-to-foreign communication. Somebody in London picks up the phone and calls somebody in Sydney, Australia. In the olden days, it was fairly easy. Actually, it was fairly difficult to tap that sort of communication because you had to tap an undersea trunk line at the bottom of the Pacific or the Atlantic Ocean to get access to that communication. Today, in the internet era, a lot of the packets that constitute that communication are now routed through servers in the United States. So it's actually much easier for the United States intelligence intelligence community to, pursuant to court order or other legal authority, listen in on email communications or telephonic communications that originate overseas and the termination of which is overseas. The only connection to the United States is that we have an awful lot of the world's internet backbone here, so it happens to be routed through here on its way to its final destination. And that raises some privacy issues, and it also raises some operational effectiveness issues. It's much more effective and much easier for our intelligence community to conduct surveillance under those circumstances. But as the caller points out, that can raise privacy concerns for citizens in other countries.
We talked earlier about just how quickly the Patriot Act was put in place. September 11, 2001, October 26, 2001, President Bush signs that into law. One of our viewers saying it's curious that Congress has not moved to correct the law as quickly as it moved to enact the original, don't you think?
Yeah, well, so it was only about 6 weeks from terrorist attack to the Patriot Act being signed into law, but that was a very, very busy 6 weeks. I think Washington was doing very little else other than drafting, revising, editing, and debating the Patriot Act. I can't remember the number of congressional hearings that were held over those 6 weeks, but more than the 10 fingers on my hand. So I think while the act was enacted fairly rapidly, it's also the case that the act was enacted after a great deal of careful study and careful deliberation and interactions between representatives of the executive branch, representatives of the Senate, and representatives of the House of Representatives as well.
Let me share with you the comments of Representative Loretta Sanchez. She sat where you are today. This past week, she is a Democrat from California. She was part of a series of closed-door meetings, one that took place in the House of Representatives, one that took place in the U.S. Senate with General Keith Alexander and others from the intelligence community. One day after the closed briefing, this is what Representative Sanchez said here on C-SPAN.
What we learned in there is significantly more than what is out in the media today. I can't speak to what we learned in there, and I don't know if there are other leaks, if there is more information somewhere, if somebody else is going to step up, but I will tell you that I believe it's just the tip of the iceberg as to, but again,
can you categorize
all these things were legal.
Can you categorize the type of information? You know more, you're saying, from this briefing than is out in the public. Worse than what the public knows now?
I don't know that worse, but probably, you know, accumulated. I mean, I think it's just broader than most people even realize, and I think that's in one way what astounded some of us too.
Nathan Sales, that was last Wednesday on C-SPAN's Washington Journal, and tomorrow we expect to have more information because General Alexander indicating that they will be releasing some of this up until now classified information that will corroborate or reconfirm what they had said publicly, that this information has prevented potential terrorist attacks.
Yeah, and it's important, very important for us to have that information. We have to do a cost-benefit analysis. These programs impose a non-negligible harm to our privacy interests, and we need to know what the offsetting benefits are on the other side of the ledger. It may be that these programs have helped prevent the next 9/11, in which case we should be told that, so we as voters and we as members of the public can engage in a rational conversation about the optimum trade-off between privacy on the one hand and security on the other. So I welcome any future disclosures that the government can give us to help us figure out, what exactly we should be doing here.
But isn't that another double-edged sword? Because as the government releases more information, the potential terrorists now know what's happening, forcing the government to take another path to try to figure out what the bad guys are doing.
Right, yeah. So there are disclosures that are helpful and there are disclosures that don't really help terrorists all that much. I think it's possible for the government to give us thumbnail sketch summaries of what it's doing in this area in a way that doesn't necessarily tip off terrorists to the scope of our surveillance activities. A good example of how that harm can materialize is from the 1998 World Trade Center trials. Osama bin Laden was under indictment for the first bombing of the World Trade Center in 1993. During the trial, it was revealed that the United States had been listening to Osama's cell phone, actually satellite phone, which I guess you would kind of expect us to be trying to do, but this confirmed it. Cell phone went dark shortly thereafter, and it was much more difficult to get intelligence on Osama bin Laden. So as the government weighs disclosing operational details or legal rationale to provide information for public deliberation, it's also important for them to withhold the most sensitive sources and methods of intelligence collection so we don't tip off our enemies that way.
If you're just tuning in or listening on C-SPAN Radio, our guest is Nathan Sales as we drill down into the details on the Patriot Act, and later we'll talk about the FISA law. Norma is joining us from Hastings, England, another viewer on the BBC Parliament channel. This program is carried live Sunday afternoons. Go ahead, Norma.
Hello, and thank you for having me on. I've
Certainly.
been on this connection twice before. The first time I spoke, it was about drones, and the second time I spoke, it was about the power of hackers in cyberspace. And now it's all about surveillance, and I think I'm outside the box in as much as the other people that seem to be on your program don't seem to be seeing the elephant in the room. Once mankind got into technology, and once mankind enabled himself to do what he does with technology, then those whom have the power to abuse it would. I mean, the fact that even most people don't understand that the trading section in the financial world is done by computers. Millions of transactions per minute are done by machine. And if anyone got into that and put down those machines in any form, the world would be in a sort of a state that we've never known before. And I think the fact that the powers that be want to keep an eye on everything just comes as part of the enter into a world that we've never entered before. And I think it's almost unforeseen what can take place, because people just nowadays, they think to interact and use their phone as a camera and translate pictures and information across the world in seconds has a price. And I just think I wrote a poem, and if I could just read the last part of it.
Certainly.
And it's about, and I've talked about the spiders wanting to do what mankind does, because several of their legs, if they could just create a wonderful entrancing web filled with unimaginable experiences beyond anticipation, which not only created a new way of seeing the world in which there is instant global interaction almost outside our comprehension, but to do it whilst weaving a much bigger one around your prey, whilst they're so taken with what's in the first, they don't even sense the second, is beyond belief. Because the way the people, it just amazes me that people are surprised by what's going on, and that's all.
Norma, thanks for the call. Appreciate you phoning in. It's good to hear from you again. We'll get a response.
Well, I think this goes back to Lord Acton. Power corrupts, and absolute power corrupts absolutely. Anytime the government or any human enterprise is given some new capability, there's always the potential that that new capability or power will be abused. And so, to return to a theme that we've discussed a couple times before, the critical question in my mind is, all right, now that we've given the government these sorts of tools, what kind of checks do we have in place? What kind of oversight mechanisms do we have in place to prevent the government from overreaching? And I think the most important one in this context is, again, the requirement of judicial review. Anytime the government wants to read your emails as an American citizen or listen to your phone calls, it has to go before an ordinary Article 3 judge and persuade that judge that there's probable cause to believe that the target of the investigation is an agent of a foreign power. What that means is probable cause to believe that the person under surveillance is a spy or a terrorist. You can't do this unilaterally. You have to go before a judge and say, please. And these judges take their jobs very seriously. They oversee the Justice Department lawyers, they oversee the NSA operators, and they make sure that they comply with the terms of the law. So ultimately, for me, the question is, how effective are the oversight mechanisms? And I think one of the most important ones that the mind of humanity has ever devised is to interpose a neutral and detached judge between the government on the one hand and the citizens on the other. And that's what we see here in the Patriot Act and the Foreign Intelligence Surveillance Act.
The cover story of CQ Weekly by Tim Starks, focusing on the intelligence issues, making this point: revelations that the NSA has been collecting the phone and internet data of millions of Americans have spurred strange alliances and, at long last, a debate about privacy that doesn't mean much will change.
Well, I hope the debate helps inform Congress's deliberations. Maybe I'm a naive law professor, but I happen to think that ideas matter. And as more information is revealed to the public and is revealed to Congress, I hope that it informs our national conversation about whether our surveillance laws should be expanded, contracted, whether we need new oversight mechanisms, or whether everything is working as the drafters of these laws originally intended them to.
Let me ask you, though, about a book that many of us might have read in high school, 1984. Is this 1984 in 2013?
If it is, George Orwell is going to be disappointed. I think Google and Apple and Amazon know an awful lot more about the average American than the government does. The government doesn't care what I had for dinner last night. And for a good reason. There's too many other high priority projects that the government is focusing on. They care about preventing terrorist attacks. They don't really care about what Nathan Sales is going to do for lunch this afternoon. And even if they did care, there would be strict constrictions and restraints on the government's ability to find that out. Going back to the FISA court, we don't say trust the government not to snoop around in our files. We say trust that the government will comply with court orders that are constantly being used to oversee its surveillance activities and are enforced by the court.
Andy is next. Clinton, New York, Democrats line. Welcome to the program.
Thank you. An object in free fall can't do work as such as crushing the columns below it. This is basic physics. Given that NIST has admitted to Building 7's free fall on 9/11, why didn't the FBI or DOJ try to find out who placed explosives throughout that highly secure building?
Okay, I'm going to put this on the table. We've had 3 or 4 calls on this. In your mind, was anyone outside of the terrorists involved in what happened at the World Trade Center or at the Pentagon?
No, full stop. If the government were involved, we would know about it by now.
We continue to get calls, though, and we welcome the conversation, but yet to have any proof that there were outside forces involved in what happened.
None whatsoever.
We'll go to Andrew next in Nottingham, England, with Nathan Sales of George Mason University, formerly of the Justice Department. Good morning.
Yes, good afternoon to yourselves. How are you going?
Hello.
Hello, can you hear me?
We sure can. Go ahead, Andrew.
Yeah, good afternoon. Basically, what I'd like to know, obviously there's a lot of companies out there making quite a bit of money through selling things like security products and things like that. And very often, whether it be mobile companies or whether it be such as Symantec with its Norton software, they all offer things like backup services. We've also got cloud-based services and etc. And obviously they pretty much ignored international boundaries. Now, obviously, as you previously stated, the United States holds significant internet backbone. What I'd like to know is that, obviously, yes, protect the country from terrorism. I agree with that 100%. Share information with your allies, etc. Not a problem. I don't do anything wrong, so I've got nothing to hide, nothing to be afraid of. But at the end of the day, there is this kind of air of, is this really the right way of going down? Should we actually start looking at maybe declaring servers as basically like virtual embassies so that they would be given diplomatic protection? So that, for example, if my personal data is being stored overseas, then because I've bought a certain company's product, should that country's authorities have access to it? I don't think so. Even though I'm doing nothing wrong, it should be for my country and my country's citizens to give me or provide feedback on the data that I choose to store or transfer.
Andrew, I'll stop you there and we'll get a response. Thanks for the call.
Yeah, it's an interesting idea. Practically speaking, I wonder how that would work in practice. So data stored on the servers of, for instance, Yemeni ISPs or Afghanistan or Pakistani ISPs would be off limits to investigators in the United States or in the UK. I mean, I don't know that is a workable rule simply because the types of communications in which intelligence is most interested, at least in the United States, typically don't originate or terminate in the United States. We're interested in communications between senior al-Qaeda officials in Waziristan on the borderlands of Pakistan and Afghanistan, and their associates down the road. So if we were to create a sort of walled garden for communications involving people of particular nations and making those off limits to surveillance from the United States and the United Kingdom, I mean, those are the sorts of things that we're most interested in. So I don't know that that would be workable in practice.
We're talking with Nathan Sales, who's a graduate, by the way, of Duke Law School and also was a research editor at the Duke Law Journal, served for 2 years at the Justice Department in 2001 through 2003, and currently is a teacher, the assistant professor of law at George Mason University, which is just outside of Washington, D.C., in Fairfax, Virginia. One more call and then one more tweet. First from Jack in Northport, Alabama. Good morning.
Good morning. I had a question about oversight. I keep hearing everybody talk about how much oversight there is on this, but I was listening to Robert Mueller being questioned the other day, and subject of True the Vote in Texas and how the FBI came by twice, the ATF came by one time, the IRS asked over 300 improper questions, all because these people simply wanted to be sure that their election was run fairly. And there's supposed to be oversight on everything they look at behind closed doors on the internet and our phone calls. Personally, I hate to lose my civil rights and watch my Constitution be shredded for 8 out of 10 of the Muslims that we're investigating are in this country illegally.
Jack, thanks for the call, which is ironically what this last tweet was about as well. Please ask Nathan Sales what proof he has that the warrants that are sought on a case-by-case basis from the FISA court are done so when the court itself is secret. So to his point and to Jack's point, how would you summarize?
Yeah, let me take the IRS point first. First of all, I don't have any brief for what the IRS is alleged to have done with respect to the tax-exempt status of conservative Tea Party organizations. The difference between the IRS's surveillance activities or operations on the one hand and the NSA and FISA context is the oversight here is judicial. Right? There's no judge overseeing the IRS on a day-to-day basis saying, yes, you can ask this question, no, you can't ask that one. We do see a comparable mechanism here in the FISA context with the FISA court. So now the question becomes, how effective a check is the FISA court on the executive branch? In answer to the second question, I think so the Justice Department and the FISA court provide regular and routine and comprehensive briefings to Congress, usually in secret, usually it's classified, about what kinds of activities are being authorized. So somebody in Congress knows what the scope of the FISA court's oversight is and whether the Justice Department is secretly engaging in wiretapping activities without FISA court authorization or things like that. If that sort of activity were taking place, my sense is that somebody in Congress would be blowing the whistle, if not publicly, then certainly privately.
And let me go back to an earlier point, because we've had a number of calls on this and because I've asked questions to the callers about evidence on their theories behind September 11th. This is from Richard, who focuses more on trust in government. He says, you shouldn't be surprised by all the conspiracy calls. It all stems from trust in government or the lack thereof. And on that larger issue, we've seen what happened with the IRS. We now have these reports with NSA. Your thoughts as somebody who used to be employed in the federal government? Yeah, well, nobody should ever trust the government, but what we should trust is the oversight mechanisms that Congress has created and that the courts enforce. The executive branch, like any fallible human institution, is naturally prone to overreach, is naturally prone to breaking the rules. That's always been the case with government action, and it always will be. And the genius of the American system is its creation of checks and balances to prevent executive overreach from happening too often and to correct it when it does. And in the specific context of national security surveillance, we see that in the form of the FISA court, which requires the government to demonstrate probable cause to believe that the target is a spy or terrorist before any wiretapping can take place. That's been the framework we've been living with since 1978 when FISA was enacted. And I think the reduction
and abuses that we've seen since 1978 compared to what came before speaks very well for the balance that Congress has struck.
Nathan Sales, formerly with the Justice Department, now a professor at George Mason University, thank you for adding your expertise to this conversation.
Thank you for having me.
Coming up in just a moment, we'll continue with our look at the FISA rule and basically how that was put in place, its impact. In 2013, it was first signed into law by President Carter in 1978. Our guest, Laura Donahue of Georgetown University, also the author of The Cost of Counterterrorism, Power, Politics, and Liberty. That's coming up in just a moment. But first, a look at the other Sunday programs, which can be heard at noon Eastern Time, beginning at noon Eastern Time, 9 o'clock for those of you on the West Coast on C-SPAN Radio. And Nancy Callow is keeping track of the guests and the topics. Good morning, Nancy.
Good morning, Steve. On today's Sunday talk shows, the topics will include, of course, national security leaks, also immigration reform and the situation in Syria. And as you mentioned, C-SPAN Radio re-airs the programs beginning at noon with NBC's Meet the Press, where today's guests include Senate Intelligence Committee Vice Chairman Saxby Chambliss, Colorado Democratic Senator Mark Udall, and General Michael Hayden. He's former NSA and CIA director. At 1 p.m., hear ABC's This Week with Florida Republican Senator Marco Rubio, Democratic Congressman Luis Gutierrez, and the former governor of Florida, Jeb Bush. At 2 p.m., it's Fox News Sunday. Chris Wallace interviews former Vice President Dick Cheney. They'll talk about the NSA surveillance program and other issues in the news. CNN's State of the Union follows at 3 p.m. Candy Crowley welcomes House Intelligence Committee Chairman Congressman Mike Rogers and the Chairman of the Senate Foreign Relations Committee, Bob Menendez. Then at 4, it's Face the Nation from CBS. Bob Schieffer talks with White House Chief of Staff Dennis McDonough, and another appearance by Intelligence Committee Chair Mike Rogers. The Sunday Network talk shows are brought to you as a public service by the networks and C-SPAN. Again, C-SPAN Radio rebroadcasts the shows beginning at noon with NBC's Meet the Press, 1 o'clock ABC's This Week, at 2 Fox News Sunday, 3 CNN's State of the Union, and finally 4 Eastern Face the Nation from CBS. You can listen to them all on C-SPAN Radio on 90.1 FM here in the Washington, D.C. area. Across the nation on XM Satellite Radio, that's channel 119. You can download our free app for your smartphone or go online to cspanradio.com.